If you're gonna be running a business, you need to understand contracts you might be signing or giving to someone to sign. You wanna make sure if you're the company handing them that they're straightforward, they match the deal that you have, and that they're reasonably fair. You don't want a client to get the agreement and say, this is nuts. That's the reason we have this drafted legal program. It's the reason we run this channel, is try to educate you to make sure you can use these legal things to your advantage to run a smooth and efficient business. So today, let's talk about some legal loopholes. So let's say you're not using drafted legal contracts, which obviously we recommend. Link below to them if you want to make sure it's done right. But if you're using your own or you're looking at someone else's, here's some of these legal loopholes you need to figure out. First legal loophole is having to do with payment. So if you are the one to be paid from the contract, so you're providing a service, product, whatever, and they pay you at some point, there's a couple triggers in there that you have to make sure you can actually get the payment. The first is there needs to be an actual trigger date for when payment is due. That also has to do with like your deliverables, your scope of service, but it needs to be, upon the second revision, payment is due, or completion of A, B, and C, completion is due. It needs to be super clear so that you can show a third party, a judge potentially, but show a third party, I've met my deliverables, payment is now due. Very important, because the contract says, I'm gonna design a logo for you and then you pay me 10 grand. So what if the other party says, no, I don't like it, I wanna go back and do this again, or do that again? Well, you keep going back and forth, and there's no point where you can say, well, now I can enforce this. I designed the logo, and they're gonna say, well, you didn't like it. And maybe you got a decent argument there. However, there is an argument. If you have it where it's really clear what the trigger date is, then there is no argument. You're owed the money. Another important loophole is if there's no late fees or interest being charged. So a lot of times, the person who's not paying you may owe money to other people. The other people might have the interest that drives urgency. So the 10 grand turns into 11, 12, 13. It keeps going up unless they pay it. Just like with your credit card, or someone else you might owe money to. So you don't want to have a stagnant amount. It just stays 10 grand for indefinitely. Third really big thing on that payment part is making sure that you have an attorney's fees clause. So if it's 10 grand, you go call a lawyer and say, this guy owes me 10 grand. Says, that's a bummer. Send me your contract. Just so you know, my retainer's somewhere between $5,000 and $10,000. And if you don't have an attorney's fees clause, you don't get that money back. So you kind of lose the cost benefit of going forward with it. If you do have an attorney's fees clause, well, then that 10 grand is owed to you, plus hopefully the interest and the fees that the attorney incurred. What all this does is hopefully prevents you from having to go into an actual lawsuit, because you can go to that person and say, hey, you owe me this money, and it's about to get really bad if you don't pay it. Please pay it, and we'll move on. So payment, make sure your payment terms are super crisp. Again, all of our drafted legal templates have this. We call it a four-corner strategy. There's another element to it that we like to put in there just to make sure you always are getting paid and prevent any disputes there. The second one is indemnification. It's kind of a mouthful, but it's a big deal. What indemnification is a fancy way of saying, look, I'll cover you for any damages that come about of our working together. So the indemnification, if it goes the wrong way, you can really be up the creek, if you know what I mean. So let's say I'm a marketing company and the indemnification says that we are indemnifying the client. Well, if something goes wrong with marketing or in their business, depending on this indemnification, they can invoke the indemnity and we have to come in and defend them or pay the damages. Really, it should go the other way around, right? The client says, look, I'm gonna indemnify you for anything. This is an aggressive marketing campaign or whatever it is. Something goes wrong or we get sued or bad press or bad reviews, you're indemnified, you're doing what we ask, and we'll take it from there. That is how it should work appropriately. But if you go read these things, they are extremely confusing. The indemnifications are those paragraphs that have like 200 words and 2 sentences and commas everywhere, and you kind of get turned around. You need to make sure that you are not indemnifying anyone. That's the short of it. Another loophole we see, it's not really a loophole, it just kind of causes problems, is related to scope creep. In that first conversation about deliverables, you got to be super clear on what you're doing for the client, because you just end up with this he said, she said, oh, I thought you were going to do this. My last marketer, my last graphic designer, my last personal trainer, they all did this, and I thought that was included. No. Everything you're going to do needs to be very specific in your agreement. The way we set them up is we attach them as an exhibit, so the agreement stays the same, and then whatever estimate, or you can just type in exactly what you're doing. That is how you avoid scope creep of someone saying, oh, let's do this, let's do that, let's do that. Say, look, I'm happy to do it, but it will be in addition, because we already agreed that I was going to be doing these things. Also helps with enforcing payment. Another loophole you might see is with termination. Let's say you've got a client signed up for a year, or there's some sort of year deal, but you can terminate the clause for any reason at any time. Well, in service deals, I actually personally tend to like to terminate, but with some sort of notice and some sort of reasonable payment thing to cover a month or 2 or 3. But you got to pay attention to what the termination is. What does it take to get out? Can you get out? Can you not get out? So there's a lot of loopholes that are wrapped in there. You want to just make sure that you understand them. Let's say you have a month-to-month marketing client and there's a lot of work up front, and you maybe turn other clients away. Well, then maybe you do want to have a termination clause where you got to give 60 days notice or something like that. But just know that in there, it'll determine how you break that contract or not. It may be, I can break this, no penalty, it doesn't even matter. So the term doesn't really matter. So you want to make sure that you understand that, because there can be changes to that make them be able to get out. Again, if it's a service agreement, I tend to like some sort of out clause, because if you're not working well together and one party's unhappy, it's just going to keep getting worse in most scenarios. So it's better to move on, get settled up on payment, make sure you have the right clauses so you do get settled up on payment, and then move forward. And then the last loophole I'd say is these kind of off the book deals, like we have marketing out there to get the client, we've been talking on the phone, emails, you got to get every term in there. You got to get every term in there, or else the integrity of the document is weakened. And it's not that difficult. You just put what your deal is on paper. Our agreements are designed to make sure you cover the pitfalls and you just kind of go through it. It'll keep it mostly the same from client to client, but then you fill in the services. So don't have deals outside of that agreement, because then the agreement doesn't matter. You want your agreement to be within those 4 corners. So that helps, one, to make sure that when you start the project, you're actually on the same page, because sometimes you really aren't. You think you're delivering something, they are expecting more. So that makes them look at it and say, look, this is my understanding. They can look at it and be like, yeah, I agree. And you're set. If they don't, then you can have the conversation that day, not when there's $10,000 at stake, and you can clear it up and say, oh no, that's not included, or yes, that's included, and you clean it up. So those are some of the ones we see the most. They're very preventable. So utilize these drafted legal templates and make your life a lot easier, make onboarding clients a lot easier with professional agreements. They do a great job for a lot of different businesses. So check out our website, email us if you got any questions. We're always there to help. Good luck.